Summarization of legal issues. My reply analyzes the impact of Sprint. Now, in Sprint Communications, the 8th Circuit, in lieu of dismissal, remanded the case at the appellate level, instructing the district court to enter a stay during the pendency of the state court action, which was not done in my case, so that they would not create potential res judicata. I did not waive my rights to federal review in bankruptcy adversarial proceeding by the path I chose. That is to say, the ULJ appeal and appellate follow-up, closing a state account, opening a new one, and seeking my EUC for that account. Indeed, to do this for each state account. As Johnson says, this is Matthew Johnson, Chief Judge of the Minnesota Appellate Court, in his order at page 3. Once a benefit account is established, the applicant may withdraw it and establish a new benefit account pursuant to Minnesota Statutes 268.07, subdivision 3BC from 2010. This is what I did. So my question fairly includes, if I lost my entitlement, which is not supposed to happen without pre-deprivation process, not post-deprivation ULJ hearings with appellate court follow-up, in other words, before they take it away, not months later dragging through the courts, still with no money. Is it because a condition of res judicata, collateral estoppel, or abstention was established because of my action? My path? It's set forward and fairly included in my question 2. So, and I conclude that I followed the right path to pursue vindication of my statutory entitlement and constitutional rights and remedies for their violation. I revisit the state proceedings here in the record, especially the order of Chief Judge Matthew Johnson, which is the petitioner's appendix B4, which faithfully sets forth the applicable Minnesota law, which was violated by respondents, and the transcript of the ULJ hearing December 1st, 2010, to illuminate my question 2, concerning the path I took to vindicate my rights. Question 2 asks, did I stumble and create res judicata for myself or some other loss of federal jurisdiction as respondents continued to insist by the path I chose? If not, the case was wrongly dismissed for want of jurisdiction, failing to undertake the federal court's unflagging obligation to hear and decide cases in their jurisdiction. Now, it is clear contradiction for respondents, on the one hand, to claim some matter was fully litigated and decided in the state's competent courts on the one hand, when I filed the federal suit, and at the same time was not resolved, as respondents insist, and barred by the Younger abstention as an ongoing proceeding. So was it ongoing or was it concluded? They're saying it was both. The district court says, after appealing to the ULJ, all the law allowed was to go through the hearing to the appellate review under Minnesota Statutes 268.105, subdivision 7A, 2010, then petition the Minnesota Supreme Court, then petition this court for certiorari, skipping bankruptcy. But by this path, no one could rule that before the deprivation I needed to have had notice and opportunity to be heard. No state entity ruled on this at all, although I raised it from the beginning. It has taken years to get benefits because of respondents' refusal to pay me when due or provide adequate due process protections. That is not Congress's law or this court's precedent. A. Conclusory statements. At the top, respondents argue at page 5 that the petition contains only conclusory statements. However, Supreme Court Rule 15.2 requires respondents in their response to, quote, address any perceived misstatement of fact or law in the petition that bears on what issues properly would be before the court if certiorari were granted. Counsel are admonished that they have an obligation to the court to point out in the brief in opposition, and not later, any perceived misstatement made in the petition. Brief in opposition is another word for the response. So once the response is in, as I understand it, respondents have waived objections to perceived misstatement of fact or law. However, my facts and law are correct. The Minnesota Appeals Court, in case number A11-254, ruled on the basis of not applying the law to me, affirming a, quote, case, unquote, in which there were no parties and applicable law was excluded. See my discussion in B, abstention, infra. Such ruling that a law will not be applied to a selected individual is not a legal ruling, but an arbitrary ruling. Now, Stoneburner, she wrote for the panel at the appellate court that reviewed the ULJ case in which there were no parties. So she's free to write just about anything she wants. So she says in her opinion at the appellate court that the changes in subsection G, coordination provisions, I've mentioned already, only apply to individuals whose, quote, benefit year, unquote, expires after July 22nd, 2010. My position would have been, and is, that the benefit year is described right in the amendment itself, subsection G. Benefit year appears in virtually every provision, 1A through D and 2A through D, and what is clear is that these benefit years are created by the state. There are no federal benefit years. My relevant benefit year was established by the state. It ended August 29, 2010, after July 22, 2010, and at the time I was eligible for and receiving EUC remaining entitlements from my Tier 1 federal account. And it stopped. I was deprived. Respondents still seek to base my exclusion of the law. They say they do not apply, twisting the effective date, provision 3B, as somehow calling me out and excluding me from a law that applies to all the others with an eligible state account. Since they say the Act does not apply, as the ULJ said, revising his original statements in our ULJ hearing that the state law only applied until the federal law took effect July 24, 2010, I don't know where that came from. They do not have to address any issues of what the statute says and why they didn't discuss this with me before cutting me off, and how they get the idea that no one who ever received EUC benefits previously could be paid remaining entitlements. Of course, all this was happening in a congressional campaign, but I attended to it. The only substantive ruling of Stoneburner was that Deed was entitled to judgment based on mootness, and that was improper. See my footnote in the next section. Number 1. Does the 2010 Act apply to petitioner? Judge Keyes, in rejecting the path I followed to get my benefits and constitutional rights, wrote, to the extent Carlson believed that the ULJ or the Minnesota courts simply got it wrong, his remedy was to challenge those decisions by filing an appeal to the United States Supreme Court, not by pursuing a civil action in this court, that's the district court. He thinks they should have gone straight to the U.S. Supreme Court. Well, respondents, their ULJ and appeals got it wrong. I am now here appealing to the court, and I believe properly, and that this court is empowered to finally act on my entitlement and related issues after 3.5 years of deprivation of EUC funds and bankruptcy. Where Judge Keyes errs is, first, I should have been able to challenge the deprivation before it happened, and to be told before the intended cutoff what the grounds were, and given a meaningful chance to respond. Instead, Deed sent me down the road to the ULJ's second accounts and bankruptcy. Secondly, the judge admits the parallel state proceedings were not resolved, yet refused jurisdiction on res judicata grounds. What needed to happen was respondents should have let this get resolved in the bankruptcy court. They didn't. It transferred. The Younger doctrine should not have applied. The district court should not have declined jurisdiction and should have ruled on the matter. Today, respondents advance for the first time the notion that while, quote, the 2008 Supplemental Appropriations Act, the 2008 Act, required benefit recipients to exhaust state benefits before receiving federal benefits, the Federal Unemployment Compensation Extension Act of 2010, the Act, does not require exhaustion, okay? But in the same breath, noting the Act applies only to benefit accounts that expire after July 22nd, 2010. And I agree with this. The Act is not retrospective. If my state benefit year had expired July 1st, 2010, instead of August 29th, 2010, I would not have been eligible to exhaust my remaining benefits before getting the zero payments provided by my new state account. The Act would still apply to me, contrary to respondents' contention, but as applied, it would exclude me from that continuing payment level, or in this case, continuing payments at all, since I was paid $0 weekly from September 2010 to February 2011. Now that's when I opened a new account. Now the reason I arranged to open a new account effective December 5th using my census benefits, but hold it up formally by agreement with Deed, was I feared the ULJ himself would rule against me because I had closed the account. Ultimately, Lee Nelson, Deed counsel, did argue mootness, and in fact Judge Stoneburner, in defiance of the order of Chief Judge Matthew Johnson, did rule against me based on mootness. At Respondent's Appendix B4, footnote 3, she held, quote, there is no longer a benefit account covering the benefit years from September 12, 2010 to September 10, 2011. And Deed correctly argues that having withdrawn this account, Carlson is not entitled to any monetary relief. So that's mootness. This is a plain contradiction of both Chief Judge Johnson and Minnesota law, as he carefully explains in the exhibit that I have submitted to the court. And I've already showed how my benefit year, my state benefit account, did expire after that date. And apparently thousands of other Minnesotans have also been denied their remaining entitlements from the federal government. And this has resulted in declassifying them as employed instead of unemployed, and it has artificially suppressed the state's unemployment rate to help out the politicians, to make it look like the economy was humming, and to get away apparently from the policy that they don't like. And they say that the act does not apply to persons who receive federal EUC benefits before its enactment. Unbelievable. Where does that come from? It's pure contrivance. Respondents argue the act does not apply to me because, quote, I am a person who received federal EUC benefits before its enactment. But the purpose of the act appears to be to maintain higher weekly benefits in subsequent years, not to exclude these people from any extended payments. It's to give them the extended payments, not to take it away from them, as respondents and Mark Dayton claim. So only beginning with Judge Stoneburner's opinion in the appellate review of my initial case, which by Minnesota law needed to be titled Carlson versus G2 Secure Staff, but the ULJ said there were no parties, and so it didn't have a name. The second case name was changed by order of Chief Judge Matthew Johnson to name the U.S. Census as a party, because the appeal must have the same title as the USLJ proceeding. In other words, Chief Judge said that the Minnesota law does not allow me to raise the issue or name the parties I wanted to raise in the appeal, and that I attempted to raise in my complaint, wrongfully dismissed in the district court. Clearly, res judicata cannot be the basis for affirming the district court's decision. Only beginning with the Stoneburner account was it opined that this is because the quote-unquote plain language of the effective date provision requires that the law does not apply to me. However, to reach this baseless and obviously wrong conclusion, she had to apply the act.